President Jacob Zuma has signed the Financial Intelligence Center Amendment Bill into law. The president says he's now confident that the minor changes adopted by the National Assembly have answered his concerns on its constitutionality. President Zuma earlier referred the bill back to Parliament because of concerns he had about warrantless searches contained in the FICA Amendment Bill. But the presidency says Zuma is now satisfied that the act addresses the constitutional concerns he had raised. Earlier this year, Parliament passed the amended FICA bill unanimously. The law is designed to combat money laundering and will ensure that prominent people are subject to enhanced scrutiny by the banks. The legislation requires the senior bank officials to approve the accounts of prominent, influential people and obliges banks to establish the source of funds, as well as monitor these accounts on a regular basis.
The president is now satisfied that the act addresses the constitutional concerns he had raised about warrantless searches. These amendments to the act further strengthen the transparency and integrity of the South African financial system in its objectives to combat financial crimes, which include tax evasion, money laundering, and the financing of terrorism and illicit financial flows.
For more on this story, we're now joined on the line by Mr. Lawson Naidoo from the Council for the Advancement of the South African Constitution. Mr. Naidoo, thank you so much for joining us on AM News. Good morning.
Good morning. Thank you very much.
Mr. Naidoo, tell us more about this Financial Intelligence Center Amendment Act. Who will it affect and how?
Well, I think this is a very important piece of legislation in our overall legislative framework to tackle corruption and in particular money laundering, the illicit flow of funds and financing of terror activities. It brings us into line with international norms and standards in this regard. And it's an important piece of legislation. As you said in your introduction, it introduces the concept of a higher level of diligence from the banks and financial institutions about their clients. It takes a risk-based approach to the Know Your Client framework that is already in place. We all know that we have to submit to banks details of our addresses and other personal information in order to have our bank accounts formalized. A higher level of diligence will now apply to politically exposed persons, which is people in the public sector, politicians in the main, who deal with state tenders and so on, as well as prominent influential persons, which is people in the private sector, who benefit from dealing with the state. And there's a higher level of diligence relating to those particular persons. Mm-hmm. And the transactions that flow through those accounts will attract a higher level of oversight by the banks, who will need to report any suspicious transactions to the Financial Intelligence Center. So it does bring us into line, as I said, with international standards. It eliminates the loopholes for money laundering that we've seen in South Africa recently.
Mr. Naidoo, do tell us, I mean, we do understand, you'd remember we've just had a recent scandal involving the bank's collusion. Do tell us, how have the banks reacted to this? I mean, we do know that private client information is exactly that. It should be private.
Well, the banks are subject of this piece of legislation. They will have to do what is required of them in terms of the legislation that has now been passed and that has now been put into place. Banks have a particular role to play in terms of ensuring that transactions that take place through their mechanisms are indeed above board. This has got nothing to do with the allegations of collusion amongst banks with relation to foreign exchange, and that is a matter that is being dealt with by the Competition Commission, and that is a process that needs to continue, so that if there's wrongdoing by the banks, that must be exposed and dealt with. But let us separate these two issues and not conflate them for the convenience of some.
And thank you for the clarification, Mr. Naidoo. Now, we also understand that if South Africa had not signed the FICA bill on its statute books by June, it could have been declared as delinquent by a task force. Please explain this to us. And what are some of the repercussions to this? I mean, we're still being shocked from the junk status downgrade.
Indeed. South Africa is a member of what is called the Financial Action Task Force, which is an intergovernmental body that regulates international financial transactions on the global level. given the interrelatedness of the banking system globally, we need to have similar levels of robustness and scrutiny within domestic jurisdictions. And this piece of legislation is bringing us into line with the norms and standards that are set by the FATF. And we've been on their radar for some time now. And in fact, we were lucky to escape without a censure from them in February this year when they met on the basis that the bill had already been passed by Parliament and was back with the President. If the President had once again failed to sign this bill before June, we would have received a serious censure from the FATF, which would have impacted on the ability of South African banks to conduct international transactions with their global counterparts. It would have had a serious impact on the capability of South African businesses to do cross-border transactions because their banking systems would be in jeopardy. So This is a critical piece of legislation. Had it been passed earlier and had it been signed earlier, it may well have played, had an impact or influence on the decision of the ratings agencies to downgrade South Africa, because one of the factors they took into account was a political commitment to counter corruption, and in particular money laundering and illicit financial flows.
That's very interesting, Mr. Naidoo. I mean, let's talk about this. I mean, we do know that the President's reasons for the delay in him signing the bill was, of course, some of the constitutional concerns that he had. Do you think they were valid, and do you think that they were now addressed in this the final draft of the bill?
Well, let's go back. I mean, the President referred the bill back to Parliament in November last year, only after CASAC had launched an application in the Constitutional Court regarding this bill. He referred it back on the very narrow grounds on his concerns about the constitutionality of searches without warrants.
Yeah.
This is a mechanism that is used in many other pieces of legislation. It's not unique to the SRC bill. It's part of African law. It's there within the Criminal Procedure Act. And I think if anybody watched the manner in which the Standing Committee on Finance and Parliament dealt with the President's concerns and reservations, it was quite clear that this wasn't really a serious constitutional challenge to the bill. And having gone through that process and submitted the bill back to Parliament in February, all that the President was then required to do was to look at that one clause of the bill. And that the fact that it has taken him 2 months to consider that one clause on what is a critically important piece of legislation, I think has to call into question the reason why the President has not prioritized this piece of legislation more highly.
Mr. Naidoo, thank you so much. Unfortunately, we've run out of time. I would have enjoyed to carry on with this conversation. That was Mr. Lawson Naidoo from the Council for the Advancement of the South African Constitution, talking to us about the recently signed FICA bill, which has been signed into law.